Okay, let's switch to a final big topic, and I imagine this is taking up a lot of your time, and that is Section 702, FISA 702 reauthorization. Why don't you briefly tell us what FISA 702 reauthorization is, and then I have some questions about it. Is that
Sure,
okay?
and this is familiar to, I know, folks in the audience here, but Section 702 is a new or relatively new amendment to FISA from 2008 that is due to expire at the end of this year. It sunsets by statute at the end of this year unless it's reauthorized. I just testified before the Senate Judiciary Committee along with a number of colleagues last week to really emphasize the critical value that Section 702 provides. I don't think there's really any doubt about the value that it provides in terms of protecting the national security, because the way it works is that it enables the intelligence community to collect against non-U.S. persons overseas without obtaining an individualized probable cause warrant when we target those individuals who are not U.S. persons and who are outside the United States and who have no Fourth Amendment rights. And over the past 15 years, it has become just increasingly important as a tool for collection. The challenge we face now is that in some of the implementation of this tool, particularly the FBI has made some significant mistakes and has a poor compliance record of the past several years, and so there's really a trust deficit that we're dealing with Congress to make sure that we're dealing with that trust deficit, and it's incumbent on us to demonstrate that we in the Bureau and the Justice Department and the intelligence community writ large can be trusted to implement this tool responsibly. And we've made a number of changes to demonstrate that we can do that. But we have some work to do to continue to convince Congress and the American people of that.
And one thing you've been trying to do, I mean, the original dominant justification of 702 was a counterterrorism justification.
Right.
And I've noticed you've been emphasizing, you may have done this in your testimony, that 702 is valuable for far beyond counterterrorism, one component of which is cybersecurity.
Right.
Can you explain how that works and why
Yeah,
that's
I mean,
so?
the tool is agnostic on the nature of the threat, right? It was the initial justification was counterterrorism, but it has proven to be extraordinarily adaptive and agile, and it's now been used in a number of other contexts, whether that's Chinese espionage and counter narcotics, fentanyl, for example, working with foreign partners there, but also in particular on the cyber threat. And chief information security officers, CISOs all over the United States should be very thankful that we have Section 702 because of the amount of intelligence we get through 702 that we then are able to provide companies to better protect them. Again, a specific example that I've talked about is the really notorious Colonial Pipeline ransomware attack, where we used 702 threat intelligence to identify the Chinese hacker and then to recover some of the ransom. Really important tool in that case, but that's just one of many examples of where 702 has provided critical intelligence in a cyber context.
So you mentioned the challenges to renewing the authorization and some of the troubles that the FBI has had. So where do you see, this is my last question, where do you see the debate now? How do you see it playing out? What are the main issues going forward? Where are we?
Yeah, I mean, there's really one core issue that I think stands out, and that is the FBI's ability to take 702 data that's been collected by NSA, which FBI gets a small portion, about 3% of the overall collection. So a very small fraction, but it's really important because that 3% relates to threats inside the United States, where the FBI has an open national security case. So the issue is the FBI's ability to simply query that data. Just like you might query your own Gmail account when you're looking for an email from somebody, the FBI conducts queries of that data. And sometimes they do so using a U.S. person identifier. And the debate is, should they have to get a warrant, for example, to do that? I think that would be an extraordinarily bad idea. That's not legally required, and it would basically shut down the FBI's ability to search data, query data that's already been lawfully collected. And I'll put it in the cyber context. Imagine hypothetically that a U.S. company has been attacked. That company's name and some of the technical indicators that are associated with that company would be really useful for the FBI then to look at 702 data. So say there's a working assumption that it's Russia that's behind that attack of that company. At the very earliest stages, one of the first things the FBI is going to want to do is put that name of that company and some of the technical information, which might also be U.S. person information, into its database to look to see, is this attack limited to this company? Has there been anything exfiltrated? Can we associate it with the FSB or GRU, Russian intelligence activity? And there's not going to be probable cause in all likelihood at the early stages to search a name of a company, right? I don't even know what probable cause would look like in that context. So I think some of these ideas, perhaps well-intentioned, are really misguided and would not be operable.
Misguided because it really narrows the significance of the program. But, okay, so my last question.
Yeah, but can I say, Joe, one more thing?
Yeah.
Misguided because it misunderstands a central lesson of 9/11. Is that it would basically recreate a divide between foreign intelligence collection and what the FBI can do to protect us here in the United States, and that's not the nature of the threat.
It would do that just by slowing down the process.
Slowing down or gutting, really, the ability of the FBI to take advantage of this collection.
Okay, so my last question is, I mean, you acknowledge and the government's acknowledged that there have been problems with compliance. There's a larger political dimension here which we can set aside, but there have been serious problems with compliance, not short-term, they've been medium-term problems with compliance with 702. And so the question is, how can you fix those compliance problems in a way that gives Congress and the American people confidence while maintaining the virtues and powers of the tool?
I mean, that is the crux of the problem, right? You just in a nutshell, identified the challenge. And one thing that I guess I would say is, like, it's not a fix the problem, it's a process, right? So compliance requires sort of ongoing understanding of the nature of the problems, what's causing those problems, and then taking steps to address them. And one of the things that we've done most recently, and it's a very simple fix and it's really had a significant impact, and that is when the FBI first set up this system, basically by default, when they searched all of their databases of other cases and other sources of information, they were by default searching this raw Section 702 data. And so many, if not the vast majority of the problems that they committed, mistakes they committed, were by inadvertently searching this data. We just flipped that default setting to require that FBI agents and analysts affirmatively opt in and then justify that search before they conduct it. And that's reduced the number of quote-unquote U.S. person queries by 90+%. So
over what period does that happen?
It's over the last year and a half that change was implemented. But understanding that problem, taking steps to fix it, and then measuring our success as we move on to the next challenge, because there are going to be other mistakes and other problems. But that's why, we need to demonstrate that we can be trusted with this sensitive information, no question. But I think that's an example of where we have taken significant steps to address a problem, and that it's paying off.